Hello, ladies and gentlemen. My name is Mark DiCarlo. Tonight, my guest is Mr. Mark Woerner. He's a candidate, he's an attorney, and he's a candidate for Judge of County Court at Law number 4. Thanks for coming on, Mark.
Appreciate you asking me.
I'm looking at a pamphlet. It states that learned at an early age the importance of giving back to his country. After graduating with honors from college and then earning his law degree from Vanderbilt University. Where's Vanderbilt?
Nashville, Tennessee.
Oh, that's interesting. Is Vanderbilt considered Ivy League too?
I
For some
believe
reason,
so,
I think
yes.
so.
The Southern Ivy League, but it's
I believe it's considered that. Was that really expensive to go back then?
not back then. In fact, I would say back when I went, the tuition was fairly reasonable compared to what you could make once you got out.
Right.
I think it was like $3,000 a year or something. So it was very easy for me to repay my student loan, which was only maybe $10,000. I don't know how they do it these days when they come out of law school owing $100,000.
Then that seems to be what the average student now owes is $100,000 to $250,000.
Yeah, it's just
But,
crazy.
I have a theory on that too. When I was a student, not so much in law school, but undergraduate in particular, we lived like students. We lived on campus. We didn't have cars. We didn't have, you know what I'm saying? We didn't eat out at restaurants, maybe at a pizza. Now, a lot of times, especially in college, I've noticed they have like middle class lives. And I could see the amount of debt to maintain that lifestyle.
Yeah, but the tuition costs are really what I think puts them in the hole, because for a university to run a law school, it's a fairly inexpensive proposition. Compared to
That's a radical thing to say.
Well,
But I would agree. I think it's not looked at very often.
Sure, you don't have laboratories
Right.
like you'd have in a medical school or a dental
Right.
school, and they're able to get students to pay the amount of tuition. But as you know, it's a tough world out there practicing law, and these young lawyers get out there, and some of them get hired as assistant district attorneys.
I know.
They can't make enough doing that to pay back their loan and actually eat.
I know, and the assistant district attorneys in particular in Nueces County, really, I don't feel are paid, even though this is an editorial statement. I'm not meaning to state that it's anyone's, Mark Skirka's fault, the DA's, but they're paid very minimal amount of money.
Yeah, I would agree with you. I think they're underpaid here.
Very, very much underpaid. And, when you see comparable positions that don't require degrees, maybe police officers or whatever, making comparable amounts, or school teachers with just a 4-year degree making comparable amounts to beginning attorneys, I don't think it's fair. There's a lot of responsibility they have. There's a lot of stress. You have to be good, you have to win. So I don't know if there's anything that could be done. I'm not that familiar with the budgets, but it is an issue here locally, I've seen.
It has been.
So, County Court of Law number 4 is actually, I'd seen you, one of the few sociable things I've done lately is I happened to go to Judge Klager's little going away party, and he was in County Court of Law number 4. He was a County Court of Law judge, correct?
Correct.
And he's retiring after many years on the bench. He's 84 years of age.
Well, he did mention that he kind of wanted to stay, but I think once he found out he was facing an opponent in the Democratic primary, I don't think he really had enough energy and time to.
Oh, I heard him say that. I thought he was mentioning that he received an opponent. I assumed he might have been referring to you, a Republican opponent.
Not at all.
He was.
fact,
He had a Democratic opponent. Who was it?
Carlos Valdez basically informed him that he was running, period.
And you're running against Carlos Valdez because,
Right.
Is that right?
I am. I had spoken with Judge Klager prior to that and said, look, if you're not going to run, let me know. I'm not going to run against you. And if Judge Klager wouldn't have faced an opponent, he probably would have decided to stay on the bench, and we probably wouldn't be having this conversation. I wouldn't be wearing this button here. But after Carlos announced that he was running, whether Judge Klager wanted to run or not, Judge Klager then informed me that he in fact wasn't going to run and encouraged me to go ahead and file.
And Carlos Valdez, of course, is now a city attorney, correct?
He is not the city attorney at this time.
Oh, he had to resign, is that right?
Not to run. If you followed things with the city attorney's office, Carlos had resigned from the office quite a while ago. I'm trying to guess it was maybe October, but
Okay.
it was before the filing deadline. He did announce that is the reason he was retiring or leaving the city attorney's office, was so he could run for county court at law number 4. But it wasn't. Let's say I don't think the two were directly related. I think he would have probably resigned anyway.
Why do you think that?
Well, I'm going by the evaluations that were done of the office after he left, by the interim city attorney as well as an outside consulting firm. And basically, if you take a look at these evaluations, they had significant issues over there in terms of the management and how things were being done, and the reports were definitely not complimentary. Although they did cite the fact that, maybe it's underfunded, and I think Carlos's response was that's the reason there were some management issues. But I think you have to read the evaluations and then draw your own conclusions.
Where could we get the evaluations from if we wanted to read them? They're probably online somewhere.
Yeah, they're online. I originally read them as they were linked in the Caller Times article, which was done back in April. However, there's, I think, other websites where I've seen reference to the articles. So you can find them quite easily.
And Carlos Valdez, of course, your opponent was, he was the county attorney when I started practicing law here.
He was.
Then he was the district attorney.
Mm-hmm.
And then, of course, obviously the offices merged into one. And then he was we're missing something. Then he was a city attorney, right?
Right. He left the district attorney's office and accepted a job with the city attorney's office.
I'm assuming he's on some sort of pension or something from the.
He definitely would have had enough time to retire from the county.
Okay. What is county court at law number 4? What kind of cases do they have?
Well, primarily the bulk of the caseload are misdemeanors.
Misdemeanor criminal cases, correct?
Misdemeanor criminal cases. And but they have all the county courts at law have concurrent jurisdiction with the district courts over civil lawsuits. So if it doesn't depend on the size of the lawsuit,
So in theory, you could file a wrongful death case in county court,
you could.
and you could be hearing it, correct?
Correct.
Do you have much? You have. Obviously, I have personal knowledge. You have a lot of criminal experience, correct?
Yes.
Yeah, DWIs, et cetera. You've tried all those, everything from DWI to murder.
So what you're asking me is, do I have any civil experience?
You're not allowed to predict the future, but I was going to ask that. But let's wait a second.
Okay.
So like on the DWIs, you've tried many DWIs, I guess.
I've tried a lot of DWIs.
I actually haven't tried many in a while. None of my clients seem to pay the money to go to trial on them, and they take probation, and then, of course, now they have some pretrial diversion in Oasis County, which makes it less likely to have to try one.
Yeah, if you have a good case that you really have a chance of winning, you're probably going to get offered pretrial diversion, and that's something you don't really want to turn down lightly. I remember a case recently where a particular defendant, I think he was an active duty Marine, which made him a very appealing defendant. His BAC was quite low.
Blood alcohol content.
Yeah, and he was offered pretrial diversion, and they rolled the dice, and he lost and got convicted. So I haven't personally had anyone turn down pretrial diversion if we get that offered for a DWI.
So to get pretrial diversion on a DWI in Oasis County, do you recall what the standards are offhand?
I do. No prior anythings.
Okay.
Not
no prior
excluding-
arrests and or convictions?
Right.
Okay,
right.
what else?
Your BAC needs to be below a .12.
Blood alcohol content, I thought it was 0.15, but it's 0.12.
Yes. And no accident involved.
Is there a requirement that you have insurance? I can't remember that one.
My recollection is that probably is required as one of the conditions of pretrial diversion.
So I'm looking at a DWI. I'm looking at a DWI video the other day. Now, as criminal defense attorneys, now we all have to look at all these videos, right?
Yeah,
There's all these videotapes that they didn't have when we started practicing, correct?
yeah. There's a lot more of that,
know.
especially in regard to taking statements from defendants.
Statements from the
witnesses.
defendants. Well, what about all the videos? I was looking at a video this last week, and I have to look at this long video of my client in the back seat of the cop car talking.
I've seen that a few times.
I thought it was more common than not. No?
I haven't seen it that often.
Okay. And the reason I'm saying that is, do you ever wonder about, just talking shop a little bit, do you wonder about the legality of them videotaping somebody in the back of a cop car? I'm wondering about the legality of that. I haven't really researched it, but I was thinking, well, do you have a right to privacy? Are you being unlawfully, my client was held a long time in the back of that police car. Are you being unlawfully detained while in the back of that cop car? And the police officer says, well, I'm writing these reports. Well, I mean, you're sitting in the back of that cop car for a long time, and you might start talking, and those statements could be used against you at trial. Did you ever have that incident come up, or that fact situation that I'm talking about?
Well, I've had a few clients, one in particular who was being filmed in the back of the car because he was carrying on quite a bit. So obviously they felt they were gathering up useful evidence against him. He was kind of raving and ranting and threatening them. Now, the problem with challenging it is if they're lawfully detained because the arrest is good, exhibition of what we call physical characteristics has always been ruled admissible. So I don't think you're going to be probably successful in suppressing that. Most of the time, too, they're not, to make it an illegal statement, there has to be a custodial interrogation. Now, it's custodial, there's no doubt of that. But they're not normally talking, they're not asking the defendant.
And in this particular case, just so, to give some idea of people what's really going on, in this particular case, no, he was not being interrogated by the police officers, but he was maintained in the back of a vehicle for some time, and he was kind of doing a narration. And in all honesty, I haven't researched the point. These were just kind of ideas practically.
Now, the police officer's narration you can object to. If he is commenting on the defendant and talking about how intoxicated he appears or whatever, I've successfully gotten that redacted from videos. The problem is if you have a defendant that's basically raving and ranting without being prompted by the officer, well, he's going to have to live with that. And I'm sure, like myself, one of the things you tell criminal defendants, or maybe ask them, is, why are you talking to the police? Because as we know, most of them dig their own graves when they do that. They think they're maybe helping themselves out, but if you're basically charged with a crime and you're placed under arrest, the main advice people need to follow is you keep your mouth shut.
Well, but don't the police basically tell you? They tell you anything you say can and will be used against you. They tell you that. I guess the statement is so simple and said maybe one time that you don't appreciate its gravity when you're told that.
Yeah. Plus, if they're intoxicated, it probably doesn't sink in. But even unintoxicated defendants I've had hundreds and hundreds of cases, probably thousands of cases, where if the defendant would have kept his mouth shut, he would have been in much better shape.
I'm amazed at the number of people. I don't recall if you do any of the federal border checkpoint cases.
I do.
You do those? I'm amazed at the number of guys that are caught on the federal, on either Falfurrias or Sarita border checkpoint, wherein the border patrol is asking questions, and they say, "Oh, yeah." You'd think whoever was having them transport this marijuana would have them say, "No, you can't search." No, but all the guys, they say, "Yes, you can search," and then usually they make additional admissions. Isn't it amazing that after all these years and all this time that people are making all these admissions to get themselves convicted of these crimes?
Well, I see that with searches all the time. Defendants, I think, believe that if they consent to a search, as if they have nothing to hide, that they're going to bluff the police officer or border patrol agent out of searching.
Oh, you think that's what it is?
That's what they think. But that I can say, for the record, to anybody out there, that has never worked. It never has worked in the past. It will never work in the future. If you give law enforcement authorities permission to search, they will search because that's what they do. So that's why I see time and time again people coming in who consented to a search. They knew they had dope in the car. And I go, what were you thinking? Did you think he went? Well, I didn't think he'd look if I'm going, no, that's what they do is they like to search. They like to investigate. And, the thing to do if they ask you for permission to search, say, no, I'm not going to give you permission to search. If they say, well, we're going to obtain a warrant anyway, say, well, go ahead. Obviously, you can do that. Now, don't fight with them. You can't resist an arrest or a search. If they try to open the trunk of your car, I don't recommend trying to tackle the police officer. They're going to do what they're going to do, but don't verbally consent to anything. Don't waive any of your rights. I'd say it's really the rare criminal defendant these days that actually asserts his rights when he has a chance to. Most of them, it could be intimidation, I don't know, but more often than not, they'll make admissions and they'll consent to searches.
Now, the last maybe year or 2 years, they now, which I think is a horrible violation of rights to privacy, etc. Now they will, in fact, do a blood alcohol content, wherein they actually will draw the blood from your body, even if you, for a DWI case, even if you say that you refuse, correct?
That's correct. In our county, doesn't necessarily apply to the surrounding counties, but in Nueces County, if you refuse to provide a breath specimen, they will then obtain a warrant and obtain a blood sample.
I'm kind of surprised the basis of, you'd think there'd be so many liability issues of somebody possibly contracting something, etc., that wouldn't even be, that the county wouldn't even want to get involved in that. Not saying that I've heard of anything contracted, not saying that I know of any malpractice that occurred, but it would seem to me there'd be some liability issues that you'd think they'd wonder about doing it.
I guess potentially there could be, but I haven't heard of any problems. And the bottom line is we normally would advise people to refuse the breath test, and now there's really no point. In a county that does blood draws, they're going to obtain a result anyway. The only difference really is going to be that you're going to get a 6-month suspension of your driver's license for refusing the initial breath test, as opposed to a 3-month suspension, which you get for failing a breath test. And I get those results pretty much instantly. As you probably know, when they're doing blood draws, those cases are going to be delayed. I think I've got DWIs that have gone, I've got at least one that went over a year before they ever filed it.
Well, that's because there's a big backlog off the laboratory in Austin, correct?
Right. I don't think they expected when they decided to mandate this blood draw that, I don't think they realized that that was going to produce a huge burden on the labs to test the blood.
Do you believe that the blood tests are more accurate than the breath tests? Are there any objective studies to establish that the blood tests are more accurate than the breath tests?
I've never seen anything that suggests that they're more accurate. However, the technical supervisor for DPS told me years ago that if we ever get to the point where we're doing blood draws, she said that you will see probably higher test results. And she goes, the same person giving a breath sample, giving a blood sample, the blood sample will probably come out a little bit higher.
I see. The limited research that I've done, not having actually tried one of the blood test cases, I look at it to me, looking at it from a juror's perspective, it's possible for me to do that. I think they're tribal cases. I don't think by any means that blood test is can't be refuted. Is that your impression too?
Yes, and there are several attorneys that have won blood test cases, and these are attorneys who tend to do a lot more DWIs than the average attorney.
Right. There are lawyers that have specialized in the DWI cases and all that. I never myself. I don't know how you feel about it. I never tried to really force my way into that market too much because I always thought they were real boring cases.
Yeah.
Did you find that too?
I tended to really do more felonies than I do misdemeanors. And while I do a fair amount of DWIs, I don't think I do nearly as many as, say, Les Cassidy, for example, or Ira Miller. And they've really focused on the scientific aspects of the blood draw and, are able to point out that it sounds to, a layman that, well, it's a blood draw, it must be accurate, but I think they've been able to point out that it's not necessarily any more accurate than anything else.
Yeah, I don't think that it is. And one thing persons may not know is, of course, your third DWI is a felony, correct?
Yes.
And they have to. How do they make it a felony, Mark?
Well, they just prove up to 2 prior convictions. That will make it a third-degree felony if you've got 2 prior A's or B's. Now, a lot of people don't realize now that while maybe they know your second DWI is a Class A misdemeanor, if you blow over a .15, then it's going to be a Class A misdemeanor. Now, still, if you had just one of those in your past, that wouldn't make it a felony. You have to have 2. Other things that people aren't maybe aware of is the DWI with child.
Yes, that's right. Often prosecuted now. Then it's a felony too.
Right.
I think
then
it's a third
state jail.
degree.
No, it's a state jail.
Okay.
So certainly they are filing lots of these cases, and people need to be aware that the enforcement on DWIs has really increased over the years. I'm sure you've noticed, like myself, you've been practicing at least 20 years, I think, haven't you?
Yeah, almost 30 years.
Yeah, myself too, and I've seen a great increase in DWI cases, and they're getting harder and harder on them.
Do you think, let me ask you, it's not fair, and if you feel any question is unfair regarding a policy decision, because as a judge, you won't be making policy decisions, but pretend you're not running for judge, and it's just informational.
I might be able to answer your question.
You may be able to answer this question. Does it work? Is it working in terms of getting less intoxicated drivers on the road, or is it working in terms of less accident and fatalities regarding alcohol? That's what I don't know if it works. And you would think, obviously, well, they're enforcing it more. It's going to work, but I don't know.
Well, you're asking me, do I think it's working in terms of reducing DWIs? I would say no. That's something I think I can answer. I think the amount of cases being filed indicates to me quite the opposite. That
in some odd ways, it's actually increasing the number of DWIs?
No, it's not really increasing it. It's just that people who commit that offense just don't really think they're breaking the law. They get in the car after they've been to the bar, had a few beers, and they're thinking, I'm fine. I don't think I'm intoxicated. And then they get pulled over and find out otherwise. I don't think the stringent enforcement really has an effect on a crime like DWI, where people don't really even necessarily realize they're committing it.
But the propaganda, or you can call it propaganda, or you can call it just news releases, press releases, or media attention. They would have one believe that the DWI crime is so evil and so abhorrent that you think people would have changed their opinion regarding it.
Well, obviously not is my answer.
Okay.
It hasn't had that result.
Are we doing these checkpoints like we're in They'll set up a checkpoint and check everybody for DWI. Has the legality of that, I can't remember. They were doing it. Was the legality of that challenged? Are they doing it in Nueces County?
It was challenged, and there's several requirements that they need to meet before they do that. My understanding is that they have not tried to pursue that here. I've not heard of any of those cases. But one thing, let me throw in one thing here though before I get sidetracked and forget. One of the things I think that is a good policy that the district attorney is doing is utilizing this pretrial diversion program. I think when you give somebody or make somebody put an interlock device in their vehicle, they're not going to be able to drive that vehicle intoxicated. Those interlock devices not only require you to blow into them before you start them up, but they periodically test you while you're driving.
Well, my understanding is now you used to have to be able to have people blow into it for you to start your car, but my understanding is now they take your picture.
Well, they take your picture, and frankly, if you had someone start your car by blowing into it, well, the interlock device is going to beep while you're driving the car and require you to blow into it again. So that guy at the bar that blew into your device, he's not there.
How much of the ignition interlock devices that you're required to have on during pretrial diversion, how much do they cost a month, you know?
I believe they're about $60 a month.
That's what I was going to say, 65.
Yeah, and I think that's a great tool to reduce the number of DWIs. Frankly, what I'd like to see the pretrial diversion program expanded a little bit. I'm not really sure I agree with the BAC cutoff of 0.12. I think you got to look at, is this person a good, hardworking, law-abiding citizen? And, you know, they basically don't have anything significant in terms of criminal history. I'm not even so sure the requirement that there not be an accident really should be in effect. I think you should look at this person who maybe is going to become unemployed because the consequences of a DWI conviction are severe. I think that also results in juries sometimes going with the defendant and giving him the benefit of the doubt because they know that this person isn't going to be able to go back to their job if they get convicted. So I don't know, the expansion of pretrial diversion to me is one answer to say, look, we're going to give you your one mistake. We're going to require you to put this in your car. You're not going to be able to drive that car if you're intoxicated. Now, there's nothing to say that they might not find themselves in a different vehicle driving it, but which would be a violation. There was quite an expectation we were going to have deferred adjudication probation in DWIs, but it looked like the legislature was going to pass it and it never made it out of some committee, however that stuff works. But I think you want to look at, do you give a citizen one chance? And I think they should be given a chance. And I think that will probably result in maybe a lot of people driving around with interlocks, but a lot of people still being able to maintain their employment. And I think that's a very important consideration.
Well, of course, that's up to the district attorney's office.
Totally up to the district attorney.
And that was instituted relatively recently, perhaps within the last 2 years. We talked about the police chief. I recall now when he first came in, the new police chief from Dallas was talking about doing these checkpoints to check everybody coming down the street or whatever for DWIs. I was very upset when I heard that initially because I really think there's people out there that are 70 years old that never took a drink in their lives. And for the state to come in and say, okay, now we're going to check everybody, even a 70-year-old person that never drank in their life, and we're going to stop you and ask you what you're drinking, I think that's just a terrible infringement upon that person's right without any probable cause or whatever. Those were my thoughts on it, and I don't think they've instituted it. That's just an editorial, a little editorial remark on that. Along with the misdemeanor of the DWIs, there's you get a fair number of thefts down there too in the county court, right? Shoplifting, etc.
Oh, yeah, there's a large number of theft cases being filed. Um, Generally, they've been very good about giving people pretrial diversion who have a clean record and don't have a history of theft. And sometimes you get a young person that goes in and shoplifts. It's a mistake, but you want to give them a chance to put that behind them and go on. And they've been very good. I've never had a problem in getting diversion for a theft case.
Well, the exception to that, of course, is there's people that, and again, ladies and gentlemen, this is Mark Woerner. He's running for County Court at Law number 4. He's nice enough to come on the show. The other thing about the theft cases is there are people that have a psychological problem apparently and or who do it for a living, and there are enhancements, increases in the sentences for certain theft cases, correct?
That's correct. I think a lot of defendants don't realize, perhaps because they went in and just pled guilty, that once you pick up enough misdemeanors, your third one is going to put you in a felony. And they don't understand that they can go into HEB and steal a package of meat or something. If they've got 2 prior shoplifting cases, they're looking at a state jail felony, and they pick up some other felonies. I've seen cases where you had someone looking at a habitual felony offender sentence of 25 to life based on a shoplifting case because they had a couple
and those
of
cases,
felonies.
Those cases a lot of times make the media, and they'll say something like, "Guy got 25 years for stealing a candy bar or something," and they like to pick that up, and it's so outrageous. But then on the other hand, he's had maybe 5 to 7 prior DWI cases. Shoplifting cases.
Yeah. I think a lot of people, when I talk to them, don't realize that was going to happen because nobody explained it to them.
But I got
as a judge, I'm going to tell somebody if they are going to be given a final conviction for a theft case. I think it's probably a good thing to do to say, look, you may think this is not a big deal because you got time served, but you could be looking at a felony if you do one more.
What's interesting on your in misdemeanor court, you don't have to fill out all the paperwork that you do in felony court, right?
That's correct.
To enter a plea. And what's interesting is, take it up on appeal, that you weren't advised that this could be used to enhance you at a later date. Therefore, you did not voluntarily waive you weren't acknowledged regarding the possible future consequences. Some sort of an argument like that.
It'd be an argument. I think I've seen it used, and I think I've seen it fail, I guess would be the best way to put it.
Well, we know how the Court of Appeal. Okay,
yeah.
You may not know. I know how the Court of Appeals is, and they primarily, no matter what the law is, in my opinion, rely upon, err on the part of the state, and they have been doing that for many years. By the way, a notable exception that I was very happy about, and I mentioned it on another show just recently, is this the discovery. Was it the Morrell decision, which enables now?
Morton.
Pardon me. Morton. I'm sorry, Morton. Decision which now the district attorney's offices, etc., have to, and county attorney's offices have to release all the evidence that they have against someone.
Well, the Michael Morton Act really codified Brady and basically said, we're going to put in certain requirements in the statute to ensure that Brady is complied with, because they've always been under an obligation to provide all the evidence, and especially anything that might be exculpatory or mitigating. Now, I think there were certain jurisdictions, and I know
there were many jurisdictions.
Yeah, I've gone out of town and practiced law in some places where the district attorney would say, well, look, I'm not going to give you any
Absolutely.
copies of anything. I think I've always thought that was reprehensible. I'm still not happy that the U.S. Attorney's Office will only provide you with the ability to look at the evidence, but not make you copies. They'll let you take notes.
Well, when I started practicing in federal court, you obtained copies.
You did.
And then the idea of the federal prosecutors was, what was represented to me is that, well, there were too many copies floating around, and then there were too many confidential names and addresses, and therefore it was too much a danger to the U.S. attorneys or the witnesses or the Border Patrol agents. That's what was represented to me was the reason locally why they no longer give you the copies.
That's what I've been told.
Is it that way? I can't remember being in another, I haven't practiced federal criminal law in another jurisdiction. Is it that way in all the federal jurisdictions you know, or just this one?
I've been told by some attorneys who have practiced in other jurisdictions that that they don't do that. They actually give you the copies. Now, I will say, to the credit of our district attorneys, past and present, they've always provided copies.
I said that in the previous show. Mr. From Grant Jones to Carlos Valdez to Mark Skirka, before this law, this Morton Act, we had an open discovery policy in Nueces County, and in my opinion, it made everything go smoother.
Mm-hmm.
And I'll tell you another thing. When the I'm assuming you'd agree with this. If you give the criminal defendant the evidence, he's much more. He can make an intelligent decision regarding whether or not to plea bargain or go to trial. And oftentimes, I think it works in the district attorney's favor because they see that evidence. They go, "Well, I got to plead guilty." They got these photographs. They got my statement. But if you didn't get the hard copies years ago, you couldn't have done that.
But don't forget, there's one negative aspect of the Michael Morton Act, and that is that it prohibits us from giving the offense reports to the defendant. Did you know that? We're not allowed to do that anymore.
I don't know. I don't know if I did know that or I forgot. But I guess that's something that we're going to be criminals if we do that? I'm just joking, but it's something to watch out for.
Well, it just says you can't do it. It doesn't say what the sanction is. Mm-hmm. There's a direct conflict, I think, with our ethical obligations. I've been told ever since I've been a lawyer that the file belongs to the client. And if a client says, I want a copy of my file, you have to give it to them, especially after the representation ceases and they're in prison or something and they want to look at their file because they might want to pursue some post-conviction remedies, or if they change lawyers if they're unhappy with you, or if they just want to fire you and represent themselves for a while and they can demand their file. So I think that putting that in the act was a serious mistake. Frankly, I haven't had it come up a lot except with one client who demanded his file. I managed to get the district attorney to agree to it, and the judge approved it. So I kind of felt like I was off the hook, but I'd like to see that changed.
That's an interesting observation. It's an interesting observation that there's this conflict between what you say are ethical duties and the rules of professional responsibility versus the law that's been codified. Mm-hmm. What about, has there been any changing regarding, along with that Morton law, was there any changing regarding what the defendant, the criminally accused defendant, has to provide to the state prosecutor?
No, there hasn't really been any change. My understanding is when this was being negotiated in the legislature, the prosecutors were obviously trying to get reciprocal discovery, which apparently didn't get very far. They obviously were the ones that didn't want defendants to obtain their own copies, and that's why that's in there. My own feeling was if there's a legitimate concern with information regarding civilian witnesses and things, they could be redacted, or we could be required to redact that information. I'm sure you've done gang cases, haven't you? In a gang case, of course, they generally will give you the discovery redacted if there's any sensitive information in there. But, if you get some guy that's busted for possession of controlled substance, the only information in there is, the police officer's name and the address of the police station. I don't really think there's anything in there we need to worry about.
I've got something else to say regarding this issue. I've never in all these years seen anybody threatened by one of my client defendants. I've never seen anybody threatened. I've never seen them call a cop, say, how dare you do, I've never heard anything untoward they've ever done. Have you? Do you have any personal experience?
I've not had any personal experience, but there have been occasionally cases where, and I've not seen it with police officers, obviously, but where civilian witnesses were threatened. That has happened. I think the recent murder case that's being tried, I think that arose out of this person the victim being a witness, and I think she was killed because of her, she was going to give testimony. But I've never experienced it myself.
Well, and then this is an aside, really, but I never discussed it on the show. There was a guy somewhere around our ages that practiced law down here, and he went back up to around a small town in Dallas, and I think he was the county attorney, and he got killed.
You're talking about Mike McClellan.
Yeah, he got murdered up
Actually,
there.
Mike,
that was awful.
That was awful. Mike was the district attorney there in this town.
That's right, some small town.
And what had happened, actually, they thought it might be drug related or gang related. It turned out they had prosecuted a local justice of the peace for some kind of bad stuff he had done, and he was the killer. He was the one that actually had first had assassinated the assistant district attorney who had prosecuted the case personally, and then he went after Mike. And frankly, after looking at what was revealed about his prosecution and some stuff on his background, I'm kind of surprised they weren't watching him
closer
right from the beginning, at least once after the assistant district attorney had been killed first, because it seemed rather obvious that he's the guy with the motive. He had the ability to carry it out. They took him seriously as a threat, and Mike was a great guy. I knew him when he practiced here.
I didn't know him very well, but I remember before he left, I had I had a lengthy conversation with him about leaving. He'd sold his home and etc. And that was pretty shocking.
Well, anybody who's a district attorney, is going to sometimes upset certain people and probably needs to.
You never had a problem here?
Oh, I've had a few, yeah. I've had a few. Notably, when I did family law, people.
Well, everybody knows that.
The
about
emotions always run high.
I've stayed away from family law for that reason. One of the reasons,
Yeah. The only time I think I've ever had a threat regarding a criminal case was I had defended a young lady who was a co-defendant in the U&I murder. Remember the U&I restaurant? The owner and a cook was.
I remember that case. Yes, sir.
And I was getting. Someone was calling me, threatening me. I told the police about it, and it was. I couldn't quite, I guess, figure out from the voice. They sounded like they were foreign origin, and it was kind of a raspy, guttural type voice.
Mm-hmm.
And I thought it was a male threatening me. It turned out it was the sister of the cook, apparently. But that kind of goes with the business. And my response to the threats when I would answer the phone was, hey, I'm in the phone book. You know where I live. Come on down.
You're a big. My brother had told me that you're very interested in guns, right? You're licensed to carry, etc. I actually had a couple guns there. I thought it might be funny to show them to you if we had time. I don't know. I actually got licensed to carry a firearm about 6 years ago, but it wasn't from the criminal element. It was from the law and order element. I had represented a couple of cases. One man was accused of child molestation,
Mm-hmm.
and they had a news story on every night on this one channel saying that they showed this horribly beaten up little girl, and every night they said Mark DiCarlo said the girl did it to herself. They ran this story before the trial and during the trial. And then around that same time, I had a woman, got a lot of publicity, who was going on the internet and representing that she had a baby to adopt out.
Mhm.
And the media, that was like a national story. They made a big deal about this story that this woman, I mean, I'm not saying it wasn't a big deal, but I mean, it was, she shouldn't have done that. But it was basically an internet fraud case. But they had these sympathetic parents on saying, oh, my, we expected this child and it was a fraud, etc. So there was this media thing. And I, one morning on the radio, I heard the lawyer that is representing that woman should be shot. And then my house got graffitied, and then some nasty. So I got licensed to carry a firearm, which I never thought. I know you're really into guns. I never thought I'd have to do, but it really wasn't from the element that you would have thought. I think it was more from, that like the man who said that was actually a doctor.
Well, I think everybody that, I mean, you've got to realize it's a dangerous world out there. And, frankly, the police are very good at, drawing the chalk outlines of the body